Some traps to avoid. Hi Alex. As promised, here's a letter warning you about some bad mental habits that a lot of students your age fall into. I hope reading this letter will not only help you do well in interview, but also help you generally with your legal studies. Relativism. Right at the start of his book, The Closing of the American Mind, Alan Bloom, a very great American academic, observed, "There is one thing a professor can be absolutely certain of. Almost every student entering the university believes, or says he believes, that truth is relative." It's understandable why students should take this position. Students, as a whole, want to be nice, open-minded, and tolerant people. And this is, of course, greatly to their credit. Now suppose that I tell you that the world is flat. There are only two ways you can react. You can tell me that I am wrong, implying thereby that I am stupid and badly educated, which isn't very nice. Or you can say, well, all truth is relative, so I'm not in a position to tell you that you're wrong. For you, the world is flat. For me, it's roughly spherical, but there's nothing for us to disagree about. We're both right, from within our different perspectives. This seems a much nicer, open-minded, and tolerant response, and is thus much more attractive to students. However, it's extremely silly to think that all truth is relative. The reason for this is very simple. We know for certain that the statement, all truth is relative, cannot be absolutely true. Because if this statement were absolutely true, then not all truth would be relative. So only two possibilities remain. Either the statement, all truth is relative, is absolutely false, in which case we shouldn't accept it. Or the statement, all truth is relative, is only true for some people, and is false for some other people, in which case, why should we accept that it's true? Either way, it's senseless to think that all truth is relative. As the philosopher Roger Scruton observes, a writer who says that there are no truths, or that all truth is merely relative, is asking you not to believe him. So don't. Well, you may say, it may make no sense to think that all truth is relative when we are talking about questions of fact. But surely when we are talking about values or morality, everyone has different opinions, and it's simply not possible to say that one person's opinions are correct and another person's opinions are wrong. So in the area of values or morality, it is true to say that all truth is relative. If you think like this, you've already fallen into another trap that I want to urge you to avoid. The trap of moral relativism. Let's try to get you out of the trap by considering a concrete example. In his great novel, The Brothers Karamazov, Fyodor Dostoevsky set out a number of documented instances of cruelty to children that occurred a couple of centuries ago in Russia. This is the last one. There was a general at the beginning of the century. A general with high connections and a very wealthy landowner. He had hundreds of dogs in his kennels and nearly 100 handlers. One day a house serf, a little boy, only 8 years old, threw a stone while he was playing and hurt the paw of the general's favorite hound. "Why is my favorite dog limping?" It was reported to him that this boy had hurt her paw. "So it was you." The general looked the boy up and down. "Take him." They took him from his mother, and locked him up for the night. In the morning at dawn, the general rode out in full dress for the hunt, surrounded by dogs, handlers, huntsmen, all on horseback. The house serfs are gathered for their edification, the guilty boy's mother in front of them all. The boy is led out of the lockup. The general orders them to undress the boy. The child is stripped naked. He shivers. He's crazy with fear. He doesn't dare make a peep. "Drive him," the general commands. The huntsmen shout, "Run, run!" The boy runs. "Get him!" screams the general, and looses the whole pack of wolfhounds on him. He hunted him down before his mother's eyes, and the dogs tore the child to pieces. A true story. So what do you think? Was it morally wrong for the general to do what he did? I hope you will say, yes, it was, and anyone who thinks otherwise is wrong. If you do, then you have to concede that moral relativism is incorrect. It is possible to say that someone's values or opinions on matters of morality are wrong. Now, if you're anything like the students I see when I interview them for places at my college, you'll probably say, Well, it's my personal opinion that it was wrong for the general to do what he did, and if I could have stopped him, I would have. At the same time, I recognize that other people might think it was okay for the general to do what he did, and if they do, I can't say they're incorrect. They're entitled to their opinion. But if you say this, then you are contradicting yourself. If you genuinely think it was wrong for the general to do what he did, then you must also think that the statement, "it was okay for the general to do what he did," is incorrect. But if you do think that that statement is incorrect, then you must think that you, I, or anyone else would be making a mistake if we said that it was okay for the general to do what he did. The truth is that moral relativism cannot be seriously defended. It's an affectation, adopted out of a laudable desire, not to be offensive or cruel, by telling other people that what they are doing is bad or morally wrong. Indeed, it's a self-refuting affectation because the people who adopt it would be the first to insist that it is morally wrong to be offensive or cruel to other people, and that anyone who thinks differently is simply wrong, not taking human rights seriously. Imagine the following conversation between two people, A and B. A. Would it be wrong for me to torture you for fun? B. Of course it would. A. Why? B. Well, I have a human right not to be tortured. A. What if you were a terrorist and you had information about an impending terrorist attack that will kill thousands of people? Would it be wrong for me to torture you to get you to tell me the details of the attack? B. B is obviously not a moral relativist. He is happy to say that torture is wrong, and that he does have a human right not to be tortured. But B does not take the idea that there is a human right not to be tortured seriously. He hesitates on the issue of whether it would be wrong to torture a terrorist in order to prevent a terrorist attack. There are two possible sources of this hesitation. Both of them are unjustified if we take seriously the idea that there is a human right not to be tortured. 1. Not wrong to torture the blameworthy. B may be hesitating to say that it would be wrong to torture a terrorist in order to extract information about an impending attack, because, while he is completely confident that it would be wrong to torture someone who is completely blameless and innocent, such as a terrorist's 5-year-old daughter, he is less confident about whether it would be wrong to torture someone who has been helping to plan the slaughter of thousands of people. But if there is a human right not to be tortured, then everyone has that right, the innocent and blameworthy alike. You cannot lose that right simply because you happen to be an evil person. 2. Society comes first. The second possible source of B's hesitation may be a nagging thought that in the situation where we could prevent the deaths of thousands of people by torturing someone, surely the interests of those thousands of people must come before the interests of the person we are thinking of torturing. But again, if there is such a thing as a human right not to be tortured, this thought is unjustified. The whole point of human rights is that they place limits on what we can do to other people in the name of social welfare or the public interest. They assert the priority of the individual over society. That is why Jeremy Bentham, who was the godfather of utilitarianism, the creed that tells us that sacrificing the interests of an individual is the right thing to do if the overall happiness of society will be increased as a result, was so hostile to the idea of human rights, declaring it to be nonsense on stilts. In the memorable phrase coined by the legal philosopher Ronald Dworkin, human rights are trumps. If you have a human right not to be treated in a particular way, then that gives you the power to veto any proposal that you be treated in that way, no matter how overwhelming the public interest may be in the proposal being carried out. It might be argued against this that many of the human rights recognized in the European Convention on Human Rights (ECHR) are qualified in nature. So, for example, the right to freedom of expression recognized in Article 10 of the ECHR may be limited or abridged so far as is necessary in a democratic society, in the interests of national security, territorial integrity or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. Does this not show that what I've said in the previous paragraph is incorrect, and that human rights can indeed be made to give way where the public interest demands it? The answer is no. To see why, we have to remind ourselves that human rights are enjoyed by everyone. Everyone has these rights because they are human beings and, as such, are endowed with a certain dignity that entitles them not to be treated as disposable commodities. If this is correct, the right to freedom of expression is not a genuine example of a human right. We don't have a right to freedom of expression because we are human beings. We have a right to freedom of expression because it is important for the health of our society that we be given a right to freedom of expression. History teaches us that democratic societies tend to flourish much more than undemocratic societies. And you cannot have a genuine democracy without giving people a right to freedom of expression. Given the social roots of the right to freedom of expression, it is hardly surprising that provision should be made for limiting this right, where its exercise would work in an anti-social way. In contrast, the rights recognized by the ECHR that can be said to be genuine examples of human rights: the right not to be intentionally killed, Article 2, the right not to be subjected to torture or to inhuman or degrading treatment or punishment, Article 3, the right not to be held in slavery or servitude, Article 4, and the right to a fair trial, Article 6, are completely unqualified and cannot be set aside or limited when the public interest demands. So if there is such a thing as a human right not to be tortured, then B should not hesitate. He should say firmly that yes, it would be wrong to torture a terrorist to extract information from him about a terrorist attack, even if thousands of people will die if the attack is carried out. But it may be that B could not bring himself to say this. If that is the case, B must concede that there is, in fact, no such thing as a human right not to be tortured. Does that then mean that it would be okay for it to torture B for fun? No. Even if B does not have a human right not to be tortured, it would still be wrong for it to torture B for fun. This is because if we weigh the pain B will suffer if it tortures him against the pleasure A will get from torturing B, B's pain will outweigh A's pleasure and make it wrong for it to torture B. Of course, such a balancing exercise produces a quite different conclusion in the scenario where B is a terrorist, and we need to torture him to prevent an impending attack. B is typical of many students that I come across, particularly at interview stage. They are more than happy to talk the talk of human rights, but when it comes to walking the walk, they stumble and fall. They happily condemn what happened in Auschwitz on human rights grounds. But after only a few minutes' discussion, they are all too willing to concede that, in fact, it might be acceptable to torture people or conduct medical experiments on unwilling patients or destroy thousands of lives in a nuclear holocaust, if doing so would serve the greater good. Don't fall into the same trap. If you are going to say that people have a human right not to be tortured, follow through and insist that it is always wrong to torture someone, no matter what the circumstances are and no matter what good might be done as a result. Finding human rights everywhere. The finality of human rights. The fact that the existence of a human right that X not be done allows the holder of that right to veto any proposal that X be done. No matter how advantageous doing X might be means that there is a constant temptation to invoke human rights as a way of establishing that it would be wrong to go ahead with a particular course of action. So, for example, if you are opposed to a local authority's plans to create a housing estate near your village, it is very tempting to try to win the argument that the housing estate should not be built by asserting that building the estate would violate your and the other villagers' human rights. If you can make this assertion stick, then you've won the day. If the local authority attempts to argue that it would be in the public interest to build the housing estate, you can argue back that that is irrelevant. Your and the other villagers' human rights trump any considerations of the public interest. Students like to invoke human rights for the same reason. It provides an easy way of closing down the discussion of an issue that might otherwise prove too thorny for them to handle. So, for example, in the case I discussed in the previous letter, where baby B has been placed in a hospital's last remaining free incubator, and baby A is then wheeled into the ward for severely premature babies. And the issue is whether baby A should be placed in baby B's incubator in place of baby B. Many students might feel tempted to short circuit the discussion of what should be done by simply asserting that baby B has a human right to stay in the incubator. Try to resist this temptation if it comes calling. Recognize what a difficult thing it is to establish that someone has a human right not to be treated in a particular way. Remember that human rights are based on the idea that all human beings are special, and as such deserve not to be treated like trash. This places a serious limit on when we can reasonably say that a proposed course of action will violate someone else's human rights. Choosing to replace baby B in the incubator with baby A because baby B is black and baby A is white would certainly violate baby B's human rights, because making such a choice involves a refusal to recognize that baby B is just as special as baby A. But it's hard to see how it could be argued that baby B's human rights would be violated if we chose to replace baby B in the incubator with baby A simply because baby A has a better chance of survival. Making that kind of choice does not involve any disregard or contempt for baby B, though it may still be wrong to take baby B out of the incubator, even if baby A has a better chance of survival, for the reasons I discussed in my previous letter. Another way of making the same point about how difficult it is to establish that someone has a human right not to be treated in a certain way is to remember how final human rights are. That is, remember that if someone has a human right not to be treated in a particular way, then it would always be wrong to treat them in that way, no matter how beneficial the consequences of treating them in that way might be. This also places a serious limit on when we can reasonably say that a proposed course of action will violate someone's human rights. How many things that one person can do to another would you be willing to say are always absolutely wrong, no matter how beneficial the consequences of doing that sort of thing might be? I can only come up with 8. 1. Executing someone else, that is, intentionally killing someone else after you have decided in a calm and collected state that that is what you are going to do. 2. Torturing someone else. 3. Having sex with someone without their consent. 4. Intentionally sterilizing someone without their consent. 5. Experimenting on someone without their consent. 6. Depriving someone of their liberty for an indefinite period. 7. Intentionally destroying or getting in the way of someone's friendship with another. 8. Treating someone with a contempt that is not based on an honest assessment of that person's character, if I'm right. And there are no more than 8 things that you can do to someone else that are always wrong, no matter what the circumstances. Then there are only 8 genuine human rights. And of course, there are even fewer if, for example, it would in fact be justifiable in certain circumstances to torture someone or intentionally kill someone. Assumptions about certainty in the law. Another common trap that I would counsel you against falling into is the belief that the law on every issue is always certain. This is simply not true. It's often very difficult to say what the law says on a particular issue. The sources of uncertainty in the law are threefold. 1. Gaps. The law is full of gaps. That is, there are lots of areas and issues where we don't know what the law says, because Parliament hasn't legislated to cover that area or issue, and the courts haven't yet been asked to decide what the law says on that area or issue. For example, suppose that I write a play that receives a great deal of acclaim. I subsequently allow the play to be performed at a theater for 6 months, on the basis that I'm to receive 10% of the box office. Suppose the play closes after 2 nights because the acting and the production received universally bad reviews in the newspapers. Could I sue the actors and the producer of the play for the money I would have earned had their acting and staging of the play been halfway competent? Nobody really knows. There's no statute governing the issue, and the issue has never come up to be decided by the courts. The law on this issue is therefore uncertain. 2. Vagueness. Legal rules are often vague, making it very hard to know how they apply in concrete situations. So, for example, The Unfair Terms in Consumer Contracts Regulations 1999 provide that a term in a contract between a consumer and a business will be invalid if, contrary to the requirement of good faith, it causes a significant imbalance in the parties' rights and obligations arising under the contract, to the detriment of the consumer. This is so incredibly vague. It will often be very hard to tell whether a given term in a contract between a business and a consumer will be valid or invalid. For example, suppose that I hire a car from you, and the car hire contract provides that if the car suffers any damage for any reason while it is in my possession, then I am obliged to compensate the car hire company for the damage done. It's uncertain whether this term is valid or not under the 1999 regulations. 3. Contradiction. On occasion, the law is contradictory. One legal rule will point in one direction, while another legal rule will point in another direction, and it's hard to know which legal rule one should follow. For example, let's suppose there are two children called Adrian and Brooke, and let's suppose that Adrian is under 18 and Brooke is under 13. Now, Sections 9 and 131 of the Sexual Offenses Act 23 combined provide that Adrian will commit the offense of sexual activity with a child if he intentionally touches Brooke and his touching is sexual. Because Adrian is under 18, Section 132 provides that in this situation, the maximum punishment Adrian can receive is imprisonment for 5 years. However, Section 7 of the Sexual Offenses Act 2003 provides that if Adrian intentionally touches Brooke and his touching is sexual, then he will also commit the offense of sexual assault of a child under 13, and the maximum punishment for committing that offense is imprisonment for 14 years. But this seems to contradict the effect of Section 132. What is the point of Parliament having provided in Section 132? That if Adrian intentionally touches Brooke in a sexual way, the maximum punishment he can receive is 5 years imprisonment, if prosecutors can evade the effect of this provision by charging Adrian with an offense under Section 7. This contradiction or tension within the Sexual Offenses Act 2003 makes it very uncertain what the legal position will be if Adrian intentionally touches Brooke in a sexual way. Thinking that the law is always certain can be damaging in interview if you dogmatically insist that a particular legal provision means X, and fail to acknowledge that it is actually difficult to tell what it means. It can also be damaging to you as a law student in answering problem questions. If you assume that the law on every issue is perfectly certain, your answer to a problem question will almost certainly be overly simplistic and fail to attend to all the issues raised by that question. So try in your studies to embrace the idea that the law is uncertain on various issues and questions. Indeed, it would be a very good idea to carry around an uncertainty book, in which you can write down any issues or questions on which the law is uncertain and suggestions as to how that uncertainty might be resolved. This will prove invaluable for your exams, as examiners often set questions around areas of the law where the law is uncertain in order. 1. To test your ability to recognize that the law in those areas is uncertain, and 2. To see whether you can intelligently discuss how the courts might resolve that uncertainty if they are called upon to do so. But don't go throwing the baby out with the bathwater. While you should embrace the idea that the law isn't always certain, you should reject the idea that the law is always uncertain. This idea, which is most closely associated with an American school of thought called the critical legal studies movement, is demonstrably untrue. If I, being of sound mind, take a rifle, climb to the top of a tower in the middle of a square, and shoot dead someone walking around in the square below, I will have committed murder. If I contract to paint your house on Sunday, and I spend that Sunday watching football instead, you will be entitled to sue me for damages. If I am an examiner, and I charge a student £1,000 to get an advance look at the paper that I have set, the exam board for which I'm working will be entitled to sue me for that £1,000 and anything that I've acquired with it. If a local authority has been allocated money by Parliament to improve transport facilities in its area, and it decides to use that money to buy cars for members of the party that controls the local authority, disaffected council taxpayers will be entitled to bring an action for judicial review. and have the local authorities' decision set aside. There is as little doubt that these things will happen as there is doubt that apples that fall off trees will always fall towards the ground. The idea that the law is always uncertain is, admittedly, very liberating for lawyers. It gives them a lot more freedom to fool around with legal rules and doctrines to achieve whatever results they want to achieve. But that feeling of liberation doesn't make the idea any more true. If I think I can fly, I may feel more liberated, but I still won't be able to fly. The truth is that if the law were always uncertain, then there'd be no point in our having a legal system at all. After all, what is the point of our having laws if they don't provide us with any effective guidance as to what we can and cannot do? If they don't provide us with any reliable information as to what actions we can bring against other people and in what circumstances? If they don't place any real limits on what the state may do to us, what are our laws for if not that? Fortunately, the law for the most part is certain, and you should resist the temptation to think that the law is always uncertain, however dizzyingly exciting such a thought may seem. Okay, that's enough advice from me for now. Again, good luck with your interview. Let me know how it goes. All best wishes, Nick.